Thank you, Rob. I'm Allison Conch. I am the program manager for Special Education Resolution Center, and I'm excited to be here today with Sharon Coppedge Long, who is the executive director of Oklahoma Parent Center, and Joanne Blades, who was the former program manager, now former assistant director of CERC. She has recently retired, but she has got a wealth of knowledge from her previous experience as an attorney and 18 years at Special Education Resolution Center. So today we'll be talking about, or starting up part one of a three-part series about due process. Joanne, are you ready for me to go ahead and share my screen and we can get started?
I'm ready.
Okay.
Okay, as Allison said, we are presenting a series on filing a due process request because this seems to be something that is pretty much of a mystery to parents in Oklahoma. Schools can file a due process, but it's more than likely that it is a parent. So we've divided a webinar series into three sections. The first one being initial considerations that a parent would have if they were considering filing due process. So this is the beginning of the first webinar. To begin the webinar, I've listed out the first three slides, and because we're being 508 compliant for accessibility, we have to keep our font at a certain level for being able to be readable. So as you look through here, we're going to go over these questions briefly, but I will be addressing each one of these questions in the webinar. What exactly is a due process hearing? What alternatives are available to try before a due process? Who is CERC and what do they do? How do I file a due process hearing? What tools will I need? Next slide. What information is helpful and necessary to know? Legal. What are the reasons upon which I can file a due process? What do I want as a result of this hearing? What kind of due process hearing should I be asking for? And what should I expect during the hearing process? Next slide. What do I have to prove at this hearing? What are legal standards? And what is a general large overview of the hearing process? So these are the items we're going to cover today. We will have two other webinars because we have so much information to share. We're not able to share everything in an hour to an hour and a half, but we hope that we're giving enough that will demystify the process for people. Next slide.
Sorry, my thing is frozen, of course.
Okay, exactly what is a due process hearing? It is a special administrative process. It is designed in the federal regulations and in federal law. So we have had parents who call us and they say, we don't like this process. We want this process changed. This process doesn't seem fair to parents. And there are some aspects of it where a lot of people will agree with that. But we are not allowed to change that. The actual process that we follow is designated in federal law. And if you want to read about it, you can Google 34 CFR sections 300.507 through 518, and it will just spell out to you what we are required to do. And they're all the things that we follow. It's all the information on our website for SDE. We don't get to make the choices of how it's done. It is very much like a court trial, and parents need to understand that. It is meant to be an informal process, but the truth is these cases that go on to court go to federal court, which is highly regulated, very formal. And so there are certain things that have to happen to make it really appropriate at the federal court level. So it seems to make them much more complicated. But in this court trial, there's a judge, which is the hearing officer, and then there's the representative of a school and the representative of the student. It could be an adult student, could be a guardian or somebody that's the parent of the student. And the hearing officer controls the hearing. They have full say outside of what's in federal regulations on how that hearing is conducted. So the hearing officer controls everything. We don't control that, the hearing officer does. We, as an entity, will assign it to a hearing officer on a random rotational basis, and that hearing officer initiates the process after it's been filed and makes sure that it follows through to the end with a conclusion and a decision. It is more formal than some other types of administrative hearings. Excuse me. I didn't know that would happen. Just go to the next slide. So sorry. Okay, what alternatives are available before filing a hearing? I don't want you to think that I'm really promoting due process. I have to tell you, in the years that I practiced as an attorney, I filed due process on behalf of parents for about 10 years. And then I was the program manager and in charge of CERC. And I really found that due process, what I would see is it wears out schools and it wears out parents. Nobody's really happy through the process. And I think most of the issues could be resolved when reasonable people sit down and try to work things out. So I think there are reasons you have to go to due process if it's very legal, but I really encourage, our whole CERC system was built on encouraging parties to resolve things at earlier stages. The IDEA provides procedural safeguards to parents in Oklahoma, and they are found at 34 CFR 300.500. You can just Google that and it'll tell you what they are. The Oklahoma Parent Center is always working with parents to understand their procedural safeguards, as are other parent advocacy agencies. Some of the things that we have available at CERC is IEP facilitation, where a parent can contact the center and ask for a neutral third-party facilitator to attend that IEP facilitation. And Sharon, I believe y'all have a lot of advocates that attend those, don't you? Oh, you're on mute, Sharon. Can you unmute yourself?
Yes, absolutely we do. It's kind of a case by case, Joanne, but
yeah,
we certainly help you prepare.
Right.
And
because IEP facilitation, the facilitator is not an advocate,
right.
But we welcome advocates, and advocates for many agencies will attend those IEP facilitations. They're welcome to be there. The facilitator's role is to facilitate and support the process of the IEP team meeting, to slow it down and have people have a full and deep discussion. Then we also provide mediation, where the parties come together over a specific issue which they disagree about. And if it is resolved in mediation, it's written down into a court document signed by the parent or the child's representative, or the child, if it's an adult student, and the school, and it's enforceable in court. If you want information about these two processes, you can look at our website. CERC's website is there, and also the SDE website. We both have information there for you. SDE has the policy and procedures manual. They have a whole section in alternative dispute resolution. So be sure to access our website, and also the Parent Center. I forgot to put on there, but their website is www.oklahomaparents with an S center.org. IEP and IEP facilitation and mediation cannot be used by anyone to delay a parent's right to file a due process hearing. And we need to make that really clear. I'm not saying that you have to do these other processes before, but I've had parents tell me how stressful it is to go through the hearing process, and you just need to be sure that you're choosing and you're preparing yourself for the procedural safeguard and the alternative that you've chosen. The other thing is, if you use the other forms of alternative dispute resolution, mediation, and IEP facilitation, it keeps the outcome in the hands of the parties. Because once it goes to hearing, you don't have any control over the decision. the hearing officer makes a decision and a ruling. And that can be scary for schools as well as parents.
Joanne, I know you're going to go a little bit further into this as we talk through the process, but I mentioning mediation, participation in a mediation session versus a resolution session, which would be part of a due process, are fairly similar. But going through mediation, like you had said earlier, is an earlier stage process, less stressful than this ordeal. And so I think it's really important for parents to just reach out and just get more information, so that if you do choose to file due process, that you're making really a fully informed decision about what that looks like. And by reach out, I mean calling our office, because once you file due process, CERC is involved, and we can talk a little bit more about that later. But our office or the State Department or Oklahoma Parent Center, and just get more information about what your options are, talk through your issues, and then you can make a decision where you're truly fully informed about what the expectations are and what your responsibilities will be.
That's exactly right, Allison. And that's the purpose of this webinar, is to help people understand what due process is. I think it is a mystery out there, and we want to try to demystify some of those issues so you know what you would be facing once that filing takes place. I've had parents file due process, and then they're surprised because the school's attorney is calling them. And I can remember being kind of miffed, thinking, well, what did you think was happening? You were initiating a legal process that's like a court trial, and you don't expect the school's attorney to contact you? I mean, I just began to realize people don't understand. Okay, next slide. Okay, who is CERC and what do they do? CERC is the Special Education Resolution Center. It's part of Oklahoma State University, and it was created in December of 2005 through a contract with the State Department of Oklahoma. So for over 18 years, CERC has managed all forms of alternative dispute resolution under special education, except for formal complaints. The State Department still does formal complaints. We won't really be talking about those today. I've listed our website, and I've given you the toll-free number and our local number if you're in the 918 area code. Would you like to answer anything, Allison? She is the new program manager. And when you call, you will be talking to Shannon, who is our administrative assistant, or you may be talking to Allison. Do you have anything you'd like to share, Allison?
Yeah, I think I'll just sort of echo what I said before, is that in really encouraging districts and parents to reach out to us. I mean, our role is to be that neutral third party and provide guidance as to, if you do this, here's what it could look like, or if this occurs, here's what that process could look like, and provide guidance in terms of what parents can ask schools for, what the school's obligations are and what they're not, and just provide a little bit of education. Like you had said earlier, Joanne, we're not an advocate for the school. We're not an advocate for the parent. We're an advocate for the process and making sure that things follow the legal procedures that they're supposed to follow, even if that just means a mediation or an IEP facilitation. So just making sure that those processes go smooth. And even if parents and schools don't end up needing any of those, calling and getting more information is always better than not, so that you go into meetings, issues, formal processes with being fully informed. So I think giving us a call is never going to hurt you.
That's right. And I can think back over the last 18 years, we had parents who called and didn't know what they wanted. We had schools who called and didn't know what they wanted. They were just frustrated with the situation. We're not getting along. We're arguing about this issue. Help me. And that's what CERC does. They help you to determine what avenues would be available to you. So it's always good to call. If you call the State Department, they're probably going to refer you to CERC. Okay, so how do you file a due process?
Oh, sorry, did I?
Yeah, you went back, go back. How do you file a due process? One time in a training for special ed directors, I had a special ed director raise their hand and say, can a parent just download a form and file a due process? And I was like, pretty much. I mean, it's not a hard process, but it's not hard to file. But once you file, a lot of things start happening. And that's what we want you to know. The OSEP and federal law requires the state to have a model form. I didn't give you any sites to the model form because I know that SDE is currently changing that. Right now, if you went to our website, you would see 4 different forms. They're consolidating that into one form, but it's not finally finished yet. So that will be changing in just a little bit of time. But you don't really have to have a form. If you don't have a form, you could send a letter. But if you send a letter, there is certain information that must be included. And that is the name of the child, the address of residence of the child, the name of the school the child is attending. And if the child is unhoused, you want to have the information that's contact for the child and the name of school they're attending. And that's all the information that is required about the child. Now, on the form, there's other information. And I was joking with the SDE saying that we could put unnecessary but helpful, because it is helpful to have a phone number, the name of the parent. All of those things are helpful. Just kind of a joke you'll understand when you see the form. So the next section, you will have to have a description of the problem with facts relating to the problem. And that becomes very, very important. You can't just write in there, the school denied my child FAPE. That's a legal conclusion. FAPE is a free appropriate public education, which is what a child in special education has a right to. But there should be at least a basic story that you could tell that shows what the problem is and what is the violation of the law. You also are required to put a proposed resolution to the extent that is known to you at the time of the filing. So it's a question that means, and so what do you want from the school? What do you want the school to do? Sharon, you have a lot of parents who call and want due process. What would you say to them about the reasons that you would file? Okay, you're muted again. Can you unmute?
What part of Part B did they violate? And then we go in and tell them about the different parts of IDEA. And we also, a lot of times, discuss that you can't, it's not because you're mad at somebody. You're mad at the principal or you're mad at the special educator. So it goes back down to basic facts. Without a paper trail, it didn't happen. So is your child being expelled habitually? Did you get copies of, we call them the pink slips? And just getting and obtaining records and keeping a, really good records of your child's suspensions or related services, whatever they may not be getting. Just be able to describe it and have a paper trail.
Yeah. So I would just tell you, if you're wanting to follow due process, you don't want to shoot from the hip and just do it because you're mad.
Right.
Because there are repercussions from that, which we will be going through in this series. But you really should be able to know some of the reasons that we see that people file due process is because they're mad at someone at the school. They're mad at the superintendent, or they're mad. But the question is, what did that person do that violated the law? Because sometimes somebody could be rude. I mean, I hate to say this, but when you get into conflict, sometimes people can be short-tempered. Somebody may have been short-tempered with you, maybe not had their best behavior, but that doesn't always mean they violated the law. So you have to look for how was the law violated. And then when you have that information together, you're going to send the request, whether it's a form or a letter, to the superintendent of your school. And you would get that address and contact information from your school on the website, or Google it, or however you would do it. And then you send a copy to the State Department of Education. If you use the model form, it's on there, it will give you information on where to file at SDE. If you're just writing a letter, you just have to Google it and find that information. It's also in the information on the forms. If you're going to file, it's a good thing to use the form, but you don't have to. Okay, next slide.
Hey, Joanne, I want to add something.
Sure.
We have a myriad of sample letters on our website that addresses every type of problem you could have. And so it's just samples that are out there that I think all parents and even educators would find quite helpful.
Okay, thank you for that.
Mm,
What tools will you need if you're filing? If you're a parent, the cost of the provision of the hearing is paid by the school district. They pay for the cost of the hearing officer at the first tier level, the due process request. They do not pay for the appeal. Our center pays for the cost of the hearing officer at the appeal. But the cost of the hearing, they pay for the transcripts, the court reporter, the location where the hearing is. But the parents have costs that are related. Some parents have complained to me about this, but that's just the way the law is set up. So parents would pay the cost of their own attorney if they have one. They pay for the supplies in getting ready for the hearing. They have to make copies of the evidence, the records of the child that they may want to submit as evidence, or maybe evaluation reports that you have from other doctors. Anything that you have on paper, there are 4 sets of notebooks that have to be prepared. And those evidence, each document is tabbed. So you can make your homemade tabs. You can take some tape and put in there. We can tell you how to do it and write with a Sharpie, but everything in those notebooks has to be the same. I always recommend parents make 1 notebook and then 3 other copies. And that is because those 4 sets, 1 goes to the school, 1 is to the hearing officer, and 1 is for the witness, and 1 is for you. So when you're in the hearing, you would be just briefly saying something like, turn to notebook 1 on evidence number 32. And everybody would turn and they'd all be on the same page. That's why it's designed that way. If you come in with just a list of documents, a stack of documents, it's going to be very confusing. So you are required to provide them in a notebook and tabbed. If parents are the prevailing party and there are legal standards to prove what that is, then the parent is able to go to court, not through the hearing process, not through a hearing officer, but go to court and ask for the school district to reimburse them for their attorney fees. And you need to be really cautious about attorney fees. If you're filing due process for improper purposes to harass, if you continue on when there's no reason to continue on, there's reasons the statute states, the school can actually come back on the parent or the parent's attorney for their attorney fees. So you really should be familiar with 34 CFR 300.517. I think this is a caution for parents who they're mad at the school and they just want to file, but they don't have a valid reason. You need to be very cautious. I know that it's not common, but I know that schools that have gone back onto parent attorneys for attorney fees and have won. That's in Oklahoma. Okay, next slide.
Joanne, just to
Yes.
clarify,
Okay.
in terms of for schools and for parents, if the parents are prevailing and want to ask for reimbursement of their attorney fees, I know you did mention that it's not at the discretion of the hearing officer to do, and it's not an automatic thing that would just be filed in, like they would have to go to the extra effort of making a separate filing to
Yes.
ask for that. Is that correct?
Yes, they would, but their attorney would know, or someone would guide them to know
Okay.
that they would actually have to go to a court. They could go to state court, which I'm almost sure if they did, the school district would remove it to federal court. And then there's a process there, but you have the ability to go in and the court will determine if you are in fact a prevailing party by a legal standard. And if you are, you submit your records, the attorney submits the records of their attorney fees and what those were and how they were calculated. And the judge will go through that and award all or some of them based on the outcome.
Okay, thank you.
Okay. Yeah. Okay, what information is helpful to know? And this is really legal. I can't really tell you every legal thing there is. Any attorney filing due process on behalf of a parent is not going to be shocked that there is a legal standard to the issue they're bringing. I mean, that's common for attorneys to understand that whenever there is a case of any kind in court or an administrative hearing, there are legal standards that you have to meet. For instance, one of the things I was thinking about was, how do you know you think your child needs to be evaluated? And the school said, no, we don't think they need to be evaluated for special ed. Well, the legal standard for whether a child should be evaluated is there any reason to believe that the child has a disability that has an adverse impact on the child's education and therefore would be in need of special services? And so I know when I go out and do training at schools, I tell them the legal standard is not. We're pretty sure the kid's going to qualify. The standard is there any reason to believe? And sometimes when parents bring in an outside evaluation, the school does not have to just follow an outside evaluation. They have to consider it, but sometimes it does give reason to believe. So that those outside evaluations should be looked at very cautiously to see if there is a reason to believe. So it is helpful for parents to know the legal standards if they're pro se. I have said that to parents before, and they've been a little frustrated at me. Like, they've said to me, well, what do I have to know? I can't tell them. And that's what's really frustrating. I wish I could. But that is why having an attorney is important, because they understand what that means and where to find them. A legal standard may be found in case law, and what that means. It may be found in the regulations. For instance, Andrew and Rowley, I think I mentioned this again later on, but they set the standard for what is FAPE. It's an IEP reasonably calculated at the time it is written, and that really comes from a 10th Circuit case, but to provide some educational benefit in light of the child's individual circumstances. And that is the standard. How much benefit? And so hearing officers measure the evidence against that legal standard when they're looking at FAPE. That's the legal standard they look for. And so when you're complaining about an IEP, my child didn't make enough progress, they're going to look at what is some benefit, what is maximum benefit. Is the parent wanting maximum benefit? I've had parents who have wanted IEPs that will increase their child's reading level by 6 years in 1 year. I don't know that the school, I'd question whether that is FAPE. Some benefit, but that might be maximum. I don't know. Depends on the child. Okay, you want the next slide? Okay, what are the reasons upon which I can file a due process? That's very clear in federal law, the reasons why you can file. And so we have two kinds of due processes in Oklahoma. We have a regular due process that has some timelines, and we have something called an expedited due process. So a regular due process, and now that the State Department is going to be changing the forms, it'll all be on one form. So you would just mark off, and we don't really take a parent's decision if they file an expedited, but it's really a regular one. The hearing officer will look at it and determine, because it makes a difference in the timelines. But anyway, a regular due process concerns the identification of a child in special education, the evaluation, whether a child should be evaluated, whether the evaluation was appropriate, those kinds of things, the educational placement of the child, where's the child placed, what is their least restrictive environment, or the provision of FAPE, the free and appropriate public education. If a school files a regular due process, there's one reason they would file, and that would be to ask a hearing officer to order an initial evaluation. So if a child is not in special education and the school says, we'd like to test your child, and the parent says no, the school has the option to go to a hearing officer and say, we have reason to believe that the child is in need of special services and has a disability and where he would be in need of individualized instruction. And so we'd like to have him tested. So the hearing officer, if they agree with that based on the evidence of the parent and the school, they could order the evaluation. But even if they order the evaluation, once the parent views that evaluation and has informed information about the child and where they're at academically, they can deny to place the child in special ed. And so forcing that initial evaluation is not the same as forcing special education. The second time of hearing we have is called an expedited due process. And I gave you the CFR number to Google. And really that is a very limited circumstance. A parent would file to challenge a manifestation determination when there's been discipline, whether or not the child's conduct was a direct and substantial cause of the disability, or if the school was following the IEP, or to contest the interim placement that the school is placing the child in during the discipline. So either one of those issues would be an expedited case. Now, it could be expedited for the school if they want to remove a student for not more than 45 school days to an alternate setting if they believe that keeping the child in the placement would be likely to result in injury to himself or others. So the school has the ability to file and ask a hearing officer to make those decisions. Again, there would be legal standards that the hearing officer would look for. There is case law that the hearing officer would use for the standard on what meets that criteria. Next slide. And then one of those questions, what do I want as a result of this hearing? You really need to know that. I mean, I can't tell you how many parents call up and tell me through the years, I want to file a due process because they're angry. And I'll say to them, what is it you want the school to do? What do you want to have happen? And they don't know. Or they'll say, I want the teacher fired, or you have to be careful about what you're wanting. So a proposed resolution might be, if you're unhappy with the change of a placement of a child, that you want that child to return to a different placement. I mean, it's what remedy is going to fix your complaint. Now, you're not stuck with that through the whole hearing, but you do have to say that what you want when you file the due process. So you really need to know, if I'm going to file this due process, what is it that I want to have happen because of that? It's an important question to ask.
Well,
Joanne, couldn't it also include like related services, like speech and language? And
Sure.
That's why it's so important to keep records. Without a paper trail, it didn't happen. So the times you've requested as a parent for evaluations, et cetera, et cetera.
Sure, it could. It depends on the issue, what you'll be wanting, but it's like, how will it resolve the problem? What is it you want the school to do to resolve the problem?
Sometimes, Joanne, I think in getting parents to think about these problems is if they can't accurately describe the problem because they're angry, and sometimes I get it, emotions fuel things, right? Almost going backwards and thinking of what do I want first, right? That could get you to the problem. If you're having a tough time understanding and describing what is it that the school has done wrong here, other than I'm mad at so-and-so, or they treated me this way.
Right.
It's what I want as a result. And if that is related to IDEA law, right, then that can help hone in on exactly, here's what the issue is, here's what I want. So even if you have to think of it backwards, sometimes that can be helpful.
Yeah, that's a good point. And I think a lot of times when parents call, they don't know. And so sometimes, I know that when I was there, and I think Allison will be the same, when you call and you're saying, well, I'm just so frustrated because they keep suspending my child. They suspend them for this, they suspend them for that. And that gives the person at CERC chance, do you have a behavior intervention plan? Are they using that plan? Is the plan working? Is the plan not working? Did they revise the behavior intervention plan? They can help you narrow down your concerns and kind of give you language to express what you're frustrated about in a way that the school would understand. I think that's a really important reason for calling CERC. Okay, next slide. Okay, what kind of hearing should I be asking for? Again, it's a regular due process or an expedited, and the new form that's coming out will be all on one one page. Regular is going to be provision of faith, identification, evaluation, educational placement. Next slide. And expedited is going to be disagree with the manifestation determination. You disagree, let's say you don't disagree with the manifestation, you don't think it is a manifestation, but you disagree with the interim placement. Like they say, but so your child will be at home and they will be on online school 1 hour on Wednesdays a week. And you're thinking to yourself, oh, that's not ever going to work because my child will not be on there. They cannot learn off a computer. They cannot do this. You have a right to negotiate that with the school when it happens and tell them your concerns. And if they do it anyway, that's another reason you might challenge it in a due process. And the expedited for a school would be to remove that child. So if a child is exhibiting dangerous behavior, that's really could cause injury to themselves or others. And it is a manifestation of their determination. I mean, it is a manifestation determination of their disability. Maybe they are very violent. They can approach a hearing officer and ask that hearing officer to remove that child to another placement for 45 days. They might do that when as time to have an expert come in to evaluate the child's behavior could be a reason. Sorry. Next slide. I'm getting over a little virus. Okay. What can I expect during the hearing process? All right. If a parent files without an attorney, then you're going to be, it's said legally that you are filing pro se. Pro se means you're representing yourself. So you're being your own lawyer. That's what it is. You're representing yourself in the issues. If you are pro se, then the school attorney will be contacting you. It might be through letter. It might be through email. It might be a phone call. But you will be contacted because you are the person representing these issues in the due process. So if you're pro se, now if you have an attorney, your attorney's going to understand that you would not be contacted. They would contact, the school attorney would contact the parent attorney. I think this is one of the issues that parents complain a lot about because many schools have insurance to pay for a defense from an attorney. And parents don't have insurance generally to pay for that. But that's the way the law is set up. If you want to change that, you got to change the law. But you are expected to follow through on all the timelines and activities and the things that hearing officer will schedule. So during the first 30 days, which we're really going to talk about next time in depth in the next module, during that time, the hearing officer is going to set up pre-hearing conferences. It's not your choice to say, I don't want to go. The school is going to set up resolution sessions. And it's really not your place to say, I'm not going. If you refuse to go, they can approach the school. I mean, the hearing officer, the school can approach the hearing officer and ask the hearing officer to dismiss the case. Now, you can say, the date you've offered me is not convenient, but I can meet on this other day. And you work out a day together. That is allowable. But again, you should read the regulations. It's all spelled out as to what will happen. And we do see parents who file due process, but they don't want to, they argue with the hearing officer or they don't want to follow the timelines and the activities. And it does result in dismissal of their case. They can generally file again, but it makes the process more frustrating. You may, during the due process hearing, you cannot contact the hearing officer by phone or by email unless you're also including the school. So if one party, it doesn't matter, it goes the other way too. The school cannot contact the hearing officer unless the parent is present in an email are present in the phone call. And that is because it's a rule called no ex parte communication. It's a rule in all court systems. It means you don't talk to the judge unless the other party's there. That would be really unfair. And I don't think any parent would like to think that the school district was calling up the hearing officer and having a sidebar talking to him. And the school wouldn't want you to do that either. It's really a process for fairness. You can directly negotiate with the school district, with the other party, which means the school, if they file it, they can negotiate with the parents. But if you are a pro se parent, you're going to be negotiating with the attorney. You will not be negotiating with the school district. Once that due process is filed, you have initiated a legal proceeding. And at that point, if the school is represented by an attorney and you want to negotiate, you will negotiate with that attorney. Could be by email, but that's where the negotiation takes place, not with the school district.
I think it's really important, some of the words and the things you're clarifying here in terms of comparing this to court. Because I think there's also, in my experience with school districts as well, there's not a great understanding that this really, it's a court system. The hearing officers, like the judge, that these are the two parties that are represented in court, even though the hearing doesn't happen in a courtroom, it happens at the school, and the hearing officer is not wearing the black robe. That's how it functions. And once due process is filed, the Office of Circ functions as the court clerk. So once that occurs, those roles become a little bit different. And that's why all of this seems very legal. It's a legal filing. And I think it's important to keep that in mind here and remember this message that you are initiating a legal filing, not just I'm going to do this thing and then the school's going to have to fix it. It's just not the way it works. And I think if people can frame their mind that way, then it maybe things won't be as shocking.
But I have seen times, I will say in my 18 years, I have seen a few times where the school refuses to do what they need to do. And the school knows that they are clearly in violation, clear in violation. And the parent has filed a due process and the school is more likely to fix it. So, I will say it doesn't occur all the time, but it has occurred. But you need to be really sure that it's usually not good advice. But you just have to be really careful. Anything can happen. I will just say anything. Okay, next slide. This is further about what you can expect in the hearing process. Resources are available to you on the CIRC website. They are also available to you in the policy and procedures manuals. The best thing is to read the regs. We do have supportive documents. We have checklists for you to use. We have due process guidelines. We answer questions for you on process. We give you verbal explanations of what's going to happen. We try to give you nutshells so you'll understand. But before you file, it's really helpful if you've read it so you know what you're getting into. Keep a file of all your correspondence and documents, just like OPC recommends that you keep all your documents in a notebook anyway, that if you're working with your child in special ed, keep copies of those IEPs, keep copies of those evaluations the school has given to you. And you will have the ability during a hearing process to ask for additional documents, but you have to present your evidence and it's going to come from those documents.
But Joanne, it could also include like emails you sent to the school requesting things. There's so much more than just evaluations in the IEP.
Yes, absolutely. Anything that could be put out on a piece of paper. Yeah, whether it be an evaluation, could be emails. Absolutely. Prior written notices. It's always important as a procedural safeguard for parents to get prior written notices. It's really important for schools to give appropriate prior written notice. And that's why, because if you didn't write it down, it's hard to prove it happened. So during this process, pro se parents will be treated the very same as an attorney would be. Now, our hearing officers are trained to be a little gentle with parents, understanding they don't know every legal requirement. They try to be not be irritated by things you don't know. They may refer you to CERC to understand more. If you're asking them questions that's not their place to tell you, they may say you need to contact CERC and ask that question. On the other side, we've had people who file due process that contact CERC and want CERC to enforce things with the school. We don't do that. So we would tell you that's something you take to the hearing officer. If you want something done in the hearing process, you have to contact the hearing officer. If the hearing officer tells you that's not my place to talk to you about it, call CERC, then that's okay. Nobody's going to be mad at you for asking, but just understand that if you don't contact the right person, you'll be referred to who is the right person to contact. It is important for you as a parent or a school to be polite, cooperative, truthful, and you should expect the same in return. There is nothing wrong with having a polite disagreement over how the law applies to your child. What makes this process worse for both parties is if you demonize the other party. If the school demonizes the parent or the parent demonizes the school and treat each other badly. I mean, people can still be polite and have a disagreement, and keep that in mind. Attorneys are taught that in law school. You should not be hateful, deceitful. You shouldn't have to be. Your position lies in your proof of the legal standard, and there's no reason. So I know it's really hard. I know it's emotional. And I know that people will tell me that they've filed something and the school district people are looking at them funny when they go to school. Well, that's going to happen. I mean, you filed something and it scares them. People get scared when legal things are filed. And if a parent files it, school personnel are a little concerned. Due process is hard on parents and it's hard on schools. Sometimes it has to happen. We always try to coach people to try to resolve it before then, but we're never going to deny that you might need to do this. Parents can be easily overwhelmed. Districts, special ed directors are easily overwhelmed by all the things, because while the parent is assembling all these notebooks, so is the school district getting that ready for their attorney. So it can be very overwhelming, but it's important to remain calm and focused. Do your research and reading ahead of time, and you can make it through. I've seen parents do it very successfully. Sometimes they have won, sometimes they have not. But I've been very impressed by some parents who are able to remain calm, focused, and present their evidence to the judge. One thing I will say, I didn't really put it in here, but I do want to say this. There are times that we receive a filing from someone and they say, my child was denied FAPE, and then they attach 200 documents. You must state in there what your legal standard is. What a due process doesn't mean that you're sending all this evidence to a hearing officer and they're going to look through it and figure out what the school did wrong. They don't do that. If you have made an allegation, say there's a problem with them not evaluating my child, that's what the hearing officer is going to focus on. And if they look at everything and say, oh, look at all these other problems, they're not going to address it. They are only going to address the allegations of the parent, and they're only going to address the evidence that is submitted to them. Did you have a comment?
Yeah, I was just going to say, I think that's super important. First of all, what you just said, so thank you for saying that in terms of making their allegations and claims. In terms of what you said about Special Education Resolution Center and our roles versus hearing officer versus Oklahoma Parent Center, I think there is still lots of confusion from parents and from schools about who does what, why, how. So thinking about Special Education Resolution Center, we are neutral. Our job is to fully inform both parties, provide education before, hopefully, for both parties, and make sure they're fully informed on what their resources are. If they end up doing something like a facilitation, mediation, or due process, what that looks like. and can provide assistance in that way. But we are not an attorney for either party. We're not an advocate for either party, but our job is to fully inform both parties and to help provide education in that way. Oklahoma Parent Center is an advocate. So if parents are looking for advocates to walk alongside them in this process, Oklahoma Parent Center is perfect to call. And then the hearing officer is like a judge, like Joanne said. So I think just trying to keep those clear. I think that's really hard for a lot of people to do, to keep that clear.
And I will add that even though Oklahoma Parent Center or any other advocacy organizations, Sooner Success, any of the others, they can stand beside a parent, but they cannot. It is not allowed that an advocate can represent a parent in a due process hearing. Our Attorney General has made that decision. We have an Attorney General decision that says advocates cannot represent parents in due process hearings. They could assist you, but they cannot represent you. And that's really important to know. The parent will have to speak for themselves.
Well, there's no such thing as illegal practice of law. We walk a really tight rope there, but we are not attorneys. We don't profess to be attorneys. We just are really, really pro-child at the Parent Center.
And you're supporting that family in the
yes,
advocating for what the child needs, right? Yeah.
Even we are really, that has been my thing for, I've been doing this for 26 years, but I don't want to be per se pro-parent as an agency or pro-district, because if you stay pro-child, all the other stuff falls by the wayside, and it just works out that way. Joanne and I had that conversation about that many years ago. You remember that, Joanne?
Well, that's what the law is about. The law is about addressing the needs of the child. The law doesn't address what the parent wants necessarily. The law doesn't address what the school wants. It's based upon the needs of the child and the ability to document what the child needs that will provide some educational benefit in light of the child's individual circumstances. And there are many, many case law out there where the judges have said in court cases that went on, it's wonderful. We understand the parents want X, Y, and Z, but that is wanting maximum progress. And the school is not required to provide maximum. So sometimes it's hard to know what is some benefit. Some parents feel my child is making no benefit. I know I raised a child on the autism spectrum, actually a granddaughter, and I did not have a perfect IEP. But she was making progress. She made a lot of progress in school. She didn't have really a social program that I thought was appropriate, but it was my job as a parent to provide the other. The school is not there to fix a child or to cure their disability. And I think sometimes that's hard for people, that they only are required under the IDA to provide enough services to provide some educational benefit. And that is hard to sort out where that is. It's hard for a lot of parents.
So many times we parents get more than FAPE. And it's really about having a relationship with your district. And I know my two boys with disabilities had crazy amount of services, but it was just talking the team into it. We literally, as parents, have to become public relations experts.
And I have to say, never in my life as a teacher or any teacher that I knew did they wake up every day and say, what is the least I can provide to this child today that I will meet the legal standard of only some benefit? I mean, most of the time, schools are providing more than FAPE in a lot of areas, maybe not every single area. But if they're providing benefit and they're progressing in their education and they're doing better, that will meet the standard. And so it's, ultimately up to a hearing officer to determine, after hearing both sides, where that is, looking at the evidence and deciding if the child has made some educational benefit in light of their individual circumstances. And what that means is if you have a severely disabled child, that child may make 6 months progress in a year. They may make very little progress compared to a child who's mildly disabled. You might expect them to make more progress within a year. And so it's all going to be based on those individual needs of the child. And that's always important. The law is beautiful when you read it. It's all about serving children's needs.
And I just want to encourage parents to understand what written notice is and that thinking and feeling and what the records will look like before an independent due process hearing officer. So it's about getting that paper trail, and it's about having your records, because you won't win without those things.
Right. But still keeping a cooperative manner. That's why it's hard to be a parent of a child with a disability, because you have to be prepared to defend your child's rights if they're being wronged. But I will say, we have over 100,000 kids in special education, and we don't have 100,000 due process hearings. I mean, I think by and large, schools are doing a really good job. It's just, as parents, we have to figure out how to meet that child's needs between what the school can provide and what we can provide with insurance or community services, or things that we can do too to maximize our child's potential. Okay, what do you have to prove at the hearing? Like, what is it that you're proving? Okay, you will have made a claim about a violation of the law. And the person who is filing the due process, whether it's the school or the parent, they have the burden of proof. There's a case called Schaefer v. Wiest that says whoever files the due process has the burden of proof. Burden of proof means they have to prove their violation by the evidence. It's up to them. The burden is upon them to prove it. And so the filing party has to present that evidence. And we have different legal terms, but like you probably heard, the standard of proof in a case for criminal law is beyond a reasonable doubt, almost certain. In due process, it's a lower standard of proof. It's called preponderance of the evidence. If you don't know what that means, you probably need to Google it. It just means more likely than not. So there is some discretion on the part of the hearing officer. They will hear this evidence, they will look at it, they listen to testimony. If two people are testifying opposite on the same thing, they're able to make credibility determinations on why they believe one over the other. So that can come into play. It's always good to have things in writing. Prior written notice is so important. If you say you do something, but like we offered this to the parent, but they didn't want it, well, where's your proof it was offered? That's why all of these things, parents should ask for that prior written notice. Schools should give prior written notice when they need to. It's all important if something comes to hearing. Okay, next.
Joanne?
Yes.
When we're talking about filing due process and it being a legal matter, focusing on what were the violations of IDEA when you're filing this, they have to provide evidence. What are some, I know you mentioned written notice, things like that, but what are some examples of evidence that a parent would need to provide if they're alleging some sort of violation? What might that look like?
Okay, let's say if there was a case about, I believe my child needs special education, and the school is saying they don't. So maybe what they would prove is their evidence would be how the child is performing at school, evaluations they've had from outside providers, any information they may have about the records of a child. And the school then would be offering evidence as to what the child is doing in school. I mean, their scores over the last few years, those would be things that as evidence. Because you're meeting, like if you're asking for an evaluation, an initial evaluation, remember the legal standard, is there reason to believe the child may have a disability and is in need of specialized instruction and special education? And so let's say the outside provider says this child has autism, and the school is saying, we don't believe the child has autism. Or maybe they say, we believe the child has autism, but we don't think it interferes with their education. So you would be presenting evidence that it did interfere with their education. Maybe they're failing. Failing is a good sign. Kids can fail. I've heard that before. Kids can't fail if they're in special ed. That's not true. They can fail. But if a child is failing without support, that is one bit of evidence that why were they failing? What support might have been needed for this child? Or a lot of it, frankly, comes down to behavior. We see a lot of kids with behavioral issues. If we're looking at hot topics, one of the hot topics we're having this year is child find. That's why I'm bringing that up, because we're seeing things happen with kids that have not been identified, which would give the school district reason to believe that the child has a disability in which adversely affects their educational performance and they're in need of special services. And adversely affects their educational performance doesn't just mean grades. It could mean behavior. If they're repeatedly being removed from the classroom, if they're repeatedly being sent home on a reduced day, then that is an indication that there could be reason to believe that the child has a problem and is in need of special education. So the evidence, you've got to know that legal standard. And if you know the legal standard is for initial evaluations or for child find, which is, child find is an affirmative obligation by the school district. I always think of it in my head visually as a picture that the school's out there beating around bushes. Yoo-hoo, where are you? You kids that need special services, where are you? And it's an affirmative obligation. They aren't supposed to wait till a parent asks for it. They're supposed to understand it on their own. And it is hard, let me tell you, because also the schools are being pushed. Don't put everybody in special ed. Be careful who you refer. You shouldn't be putting kids in special ed just because they're having trouble. Maybe you should figure out if it's something else that's going on. So there is always tension on these issues. That's what makes it tricky, because sometimes you see parents who are demonizing, they don't want to do this for my child, but you see a school, the parent doesn't understand the life of a school person that's being told, maybe you should try other things. We can't have that many kids in special ed or we'll be in trouble. And so there's that tension, but that's where it comes to hearing. If you can't resolve it through a mediation or an IEP facilitation, and I will tell you, in our system, we provide many more services up front to try and resolve these issues initially. Because sometimes we'll see an issue like, I think the most requested service over time has been an aide. I want my child to have a paraprofessional. Well, I think that's because parents know about paraprofessionals and they think my child is not doing well in school. They need a para to help them, to be with them in school. And so you get into this some kind of dichotomy where the school is saying, you don't get a para, and the parent's saying, I want a para. You don't get a para. I want a para. You don't get a para. And you come into IEP facilitation and somebody blows the whistle and says, time out. Tell us about this kiddo. Why do you think they need a paraprofessional? Well, the parent tells you, I'm worried he's not getting his work done. I'm worried he's overwhelmed at homework at night. I'm worried about all these things. And then that gives the school the opportunity to look in their toolbox and say, what other services could we do? There's many things that could happen to reduce the amount of work, as long as it's not lowering the child's level, but to sometimes schoolwork can be redundant, getting rid of those things that are redundant, giving support services that the school knows about. They have a whole toolbox they can pull from. And so we kind of nip that issue in the bud and resolve it by around, again, as Sharon said, not what the parties always want, but what are the needs of the child? How can we meet this child's needs so they can make progress in their educational environment? They need to make progress, some educational benefit.
Joanne, speaking of, these are really hot topics, but we haven't had this in over 20 years, but there are districts that are precluding children with disabilities from attending school because they're not potty trained. I mean, we've really done a lot of step back too. So that's where written notice is so important to teach parents. And we work on that all the time. But
Yeah. And, we have hot topics. That's not really the purpose of this,
right.
PowerPoint, but there are hot topics. I know a lot of times Sharon has conferences around the state and she talks about hot topics. I know the school districts have trainings where people come in and remind them the hot topics. I know Sharon and I for years did a training for new directors where we talked about the calls that we get. What are the calls we're getting? And sometimes districts are just amazed that we're even getting those calls because we've had a huge turnover of staff and the lack of special ed knowledge changes among the school districts. I mean, there's so many challenges to the system, but I'm a big proponent and trying to get call the parent center when you have those frustrations, and let's try to get some services in there to help resolve this at the earliest stage possible. And then if we can't do that, due process is something you can look at. Now, you can look at it at any time. There is no requirement. People will say, well, what do I have to do before filing it? Do I have to do a mediation? Do I have to do this? No, you don't have to. You can print a piece of paper off the internet and file a due process. But when you do, you're initiating a legal proceeding, and we just want you to be prepared for that. Or if it's helpful to you and your family and your child, if there's a way you could settle it before you get to that, we're all about trying to help you get there.
Earlier, I was talking to Allison, and she said about the due process. I think that is so funny about the expedited hearing, but it's so true. You shouldn't be following due process and planning on going on a cruise within that, timeline.
That's right. Did you talk about that, Allison, yet?
No, I don't think we're there yet, but yeah, there's
Okay.
there's a lot that goes into this, and we'll see more here in a minute. But yeah, it's a lot.
Yeah,
There's
it's
a lot of
funny.
burden on
Okay,
schools.
keep going. Next slide.
Okay.
Okay, this is a large overview of what happens in the due process hearing. Now, in our next webinar, on the next module, we'll be talking about that 30-day resolution time period, and everything that has to happen is you're getting ready. You're trying to negotiate a settlement. You're trying to settle it with the school district. But if it can't be settled, you're getting ready for hearing. So there's a lot going on, and we will be in depth at that in the next one. But this is a large overview. So there's a filing. It's considered filed when both the school and the school district receive it. If you have a regular due process hearing, you're going to have a 30-day resolution time period, which means it really is called a due process complaint notice. And what it says to the school is, if you don't resolve my problem within 30 days, then this will spring to life as a real due process hearing, and the hearing will begin. So you have this 30-day resolution time period. Now, it's adjustable. There are things that can cut it short. There are things that can extend it a little bit, but I'm just giving you the broad overview. You will have an initial pre-hearing conference with the hearing officer. So while that 30 days is going on, there's two lines of activity. The school is trying to resolve it with you, and the hearing officer is trying to intervene to make sure all the things are happening during that 30 days. So you'll have an initial pre-hearing conference with the hearing officer to set a scheduling order about what needs to happen, what the parties are doing, making sure they're cooperating. Then the school is required to set a resolution session within 15 calendar days of the hearing. Now, we can provide a neutral third-party facilitator. You have to request it. The school does not have to assign it, but it's not uncommon for the school to contact us and say, we would like to have a facilitator at the resolution session. We will also, CERC, I say we, although I'm retired, CERC would reach out and say to the parent, are you wanting a facilitator? Both parties, okay, you have to attend a resolution session unless You say, I'm not going to attend the resolution session, but I'm going to waive it. Both parties waive it, and they want mediation instead. Now, there are some differences between resolution and mediation. They're very much the same. We'll talk more in depth next time. But sometimes parents want to go to mediation. Resolution sessions and mediation, they both end in a document that's signed by the parties and is enforceable in federal court or state court. It's forcible in court. In the resolution session, if the parent is unrepresented, the school cannot bring their attorney. So where we have pro se parents filing, it's most likely, it's up to the parent. We tell them the differences, but most parents elect to go on and do the resolution session and ask for a facilitator. But if they agree to go to the mediation, if the parent doesn't have an attorney, the school can bring their attorney to that. But still, it's a time of discussion of the issues where they're trying to get a resolution and a document where it's signed by all the parties that resolves the issues. If the parties can waive the resolution session and say neither of us even want that, we are so sick of working this out, we just want to go to hearing. I can tell you in my 18 years, nobody did that. We didn't have one case. Maybe it will happen in the future. I think one reason people don't do that is the timeline would be so quick. You couldn't be ready for a hearing that quick. 15 days is not long to be ready with evidence and interviews and all those kind of things, but that's just a comment. And then after that resolution or mediation, there is a second pre-hearing conference if it doesn't resolve, where the parties are getting ready to go into hearing, where they talk more about, because sometimes maybe you have 3 issues you're bringing, but you resolve 2 of them, but there is still one going on. So you would tell the hearing officer, we resolved 2, the only issue going forward to hearing is this one. And so that second pre-hearing conference just helps the hearing officer know. Now, after the resolution time period is over, might be 30 days, might be less than 30 days if the parties waive it to go to hearing, could be more than 40 days if they agree to, 30 days if they agree to go to mediation. But whenever it's over, a 45-day hearing timeline begins. So the hearing process springs to life. It's been kind of sleeping in there, but it springs to life. And the federal government would like to see us have it done within 45 days. There's a lot of pressure on districts through OSEP not to string these things out. Next slide. So that 45-day calendar of the hearing timeline, the school is going to set the location of the hearing. And at the time of filing, the parties are given a date for the hearing. The hearing officer selects a date. It's usually about 12 to 13 days into that 45-day calendar time, but they choose it. And then if the parties can't make that date, they can make some adjustments with the hearing officer. A party could ask for an extension of the timeline for some reason, but it has to be granted with caution by the hearing officer, and it has to be for a good cause. That hearing officer is thinking about, is the child in a good place? How much is this going to harm the child? Can the child, is this necessary? So I think this is where Allison was talking about, making a joke earlier when we were going through this. Allison, you want to talk about that? Parties who filed the due process?
Yeah, on these timelines, unless otherwise specified, and I think it's only in the expedited one, they're calendar days, not school days. And especially when you get to the expedited timeline, the number of days in which a resolution session or the steps have to occur can be quite fast. So let's say you file something on December 18th. Well, your resolution session has 15 days to happen in a regular due process filing, and expedited at 7. I think we'll get to that in a minute. But so even if you do want to file, and I think this still goes back to, again, don't jump the gun on filing quickly just because you're angry. Really think about what it is you want to file about. Is this the right step? Again, we're not going to stop you from doing it. It is your right. But thinking through, is this the right step? because of the requirements. So like, yeah, like what Sharon said is, if you're about to go on a cruise, don't be filing due process right before you leave, because you're obligated to meet timelines. Once you
Yeah,
have,
and the hearing officer is not probably going to say, we'll grant you a month so you can go on your cruise.
right,
They're not going to do that. Yeah.
No.
And that's the other thing. Like if it's filed over Christmas, I mean, if the parties can't get it, but let's say it's filed the day before Christmas and you have to have a resolution time in 7 days, you have to, it says 7 calendar days. And the OSEP, the federal government, doesn't care if you're on vacation. You're going to have to bring the people back in and you're going to have that meeting. Now, in an expedited hearing, the hearing is set for school days. So it would skip those periods like spring break or the days that school wasn't in session. But if it's not expedited, and I mean, these are the things that come into play. So if you file it, you better be ready to move. Sometimes we've had parents file and they'll say, well, I don't have any of these evaluations. Well, you've got 30 days to get them ready. I mean, there's going to be pressure. Now, they want you to have a fair shot, but the hearing officer, OSEP, and the federal government do not want these hearings strung out. I mean, they monitor the state monitors the districts. So they're very cautious in if they're giving extensions. And in an expedited due process case, no extensions can be granted. None. They cannot be for any reason. And the hearing decision comes out 10 school days after the hearing. So you can see it's like the federal government is saying, we want an answer to this because it's discipline and a child is being removed from school. And we really want to know, we want this resolved as soon as we can for the benefit of this child. So they're very serious about it. It's not something that, when you file it, you need to be aware of what you are initiating. That's the point. We're not discouraging you from doing it, but you need to be aware. Okay, next slide. Okay, in my 18 years at CERC, my years as an attorney, my years as a teacher, I will tell you that my personal recommendation to all parties is don't learn about due process last minute. There's just no reason. You can read the federal regulations. They're really kind of interesting. A good place to begin is at 34 CFR 300.300. And that's the procedural safeguards. It talks about mediation. It talks about all kinds of things that need to happen that are highly regulated. You can even go to 300 and start reading there because there's definitions. Everything in the IDEA is defined in federal law. The qualifications for categories of which you may be trying to, have your child or the school may be deciding on. There are things that are highly regulated by the state. What has to be part of the evaluation? Some of the issues that parents call about, they're concerned, why is the school doing this? And we have to explain to them because they're required by state and federal law. They have criteria they have to follow. They don't get to just make it up.
Right.
And so special ed feels like a mystery. I jokingly tell people special education is the best kept secret in Oklahoma. It's a mystery, but it's not a mystery if you'll read the regulations. I know that parents go to Wright's Law and they learn about where the federal statute is. They're given a book. If you have that, open it up and read those regulations. You don't have to read everything, but Part B is helpful to read. But you need to be prepared as a parent. You can work with advocacy agencies. The Oklahoma Parent Center has information that they send out, like they have something called the Super Six. And it's the Super Six principles of the IDEA. And if you understand those 6 principles, you've got it. We give that information to school districts because I don't think people in school get enough time to really even understand special education in general, teachers, principals. Hopefully they will do outside training, but I just really recommend that anybody investigate, learn your rights, learn what you have a right to and what those mean, and be prepared as you're advocating for your child. You don't want to go in as, I'm going to sue you if you don't do this. You want to be collaborative and work together, but you should be informed so you're not caught off guard at the wrong moment. Okay, our next module will be next Wednesday, and it will provide basic information about what's going to happen during the resolution time period. It's a lot of detail. It's spelled out in the regs, and so I'll try to help. It takes people a long time to even understand it, honestly, because that 30-day resolution time period can be cut short, it can be extended, all these options that are given. And honestly, our state is monitored for this. So we must follow all those regulations. We don't have the ability to change what this process looks like, but we want you to be informed about what it is. And I hope you've learned a lot today, practical considerations that you wouldn't read in the regulations, but something that will help you understand this more. And we will see you next module. Thank you very much for attending.
Thank you, Joanne.
Thank you all. I don't think we've got any questions in the Q&A. Hopefully that this was helpful, informative for all attendees.
Be sure to remind everybody to fill out their evaluations. Or do y'all do those, Joanne?
Did you include an evaluation, Rob?
Yes, the evaluation will be there once I close the meeting.
Oh,
Okay.
okay.
All
Thank-
right, and we appreciate your comments.
Thank you.
Thank you very much.
Thank you.
Thank you.